I think we have participants are slowly joining. I think we can begin. We've also started live streaming on YouTube, so participants can always see a recording of this later as well. Is it okay for everyone? Can we begin? Yeah. Yeah. Thank you very much for joining, everyone. Welcome. My name is Mohit. I'll be the moderator today. Asta, can we end the screen sharing and begin? Yeah. Thank you.
Hello, everyone. A very warm welcome. Okay, so I'll start with about our firm, Mohit Mokal Mediation. So it is a private consulting service for civil and commercial cases by out-of-court dispute resolution mechanism. We specialize in negotiation, mediation, and arbitration. Mohit Mokal, the founder, has trained more than 1,000 students and successfully concluded several training programs, both virtual and in person, with leading universities in India including National Law University Odisha, Nalsar, Maharashtra National Law University Mumbai, and many more. We also have strategic partnership with esteemed institutions like Avi University Bangalore to promote negotiation and mediation among students and professionals. Mohit sir is also engaged in developing legal tech tools enabled by artificial intelligence and machine learning. Over to you, Mohit sir.
Um, Thank you for the warm introduction, Asta. Before we begin today's session, I'd like to also introduce our panelists. Uh, Firstly, we have Vishwam Jindal. Vishwam is the co-founder of WebNyai, one of India's leading online dispute resolution institutions. Vishwam is qualified as an advocate in India, a solicitor in England and Wales, and a registered attorney in the United Arab Emirates. With over 9 years of experience working in prestigious law firms like DLA Piper, Linklaters, and many more, Vishwam has played a crucial role in advancing the ODR landscape through his work at WebNet. Vishwam is also a dear friend and a very generous supporter of Mohit Mokal mediation from the very beginning. Thank you, Vishwam, for joining us.
Thank you,
Uh,
Mohit. Thank you for having me as well.
Thank you. Next, we have Deepika. Deepika is a distinguished lawyer with over a decade of experience across different sectors. Deepika's career began in corporate and civil and commercial litigation in Karnataka. She later transitioned into the policy domain, working with the very famous Vidhi Center for Legal Policy, where she led significant judicial reforms initiatives like Jaldi. Deepika's contributions have been instrumental in integrating technology into the judicial system and improving the court and case management practices across different high courts in India. As a co-founder of Cord, Deepika has been at the forefront of providing accessible and efficient dispute resolution avenues. Welcome, Deepika. Thank you so much for joining us.
Thanks, Mohit. Looking forward to the discussion.
Yes, thank you. Lastly, we also have Aksheta, very close friend of mine. Aksheta is the co-founder of Sama, an innovative online dispute resolution platform that doesn't need too much introduction. Sama has gained national traction, and recognition. They were recently featured at Shark Tank as well, where they received, I think it was 1 crore for 1.5% in Sama. Congratulations on that. Now, Aksheta's leadership has also been in the Indian Mediation Week campaign, which was supported by the Supreme Court Mediation Committee, Niti Aayog, and the Ministry of Law and Justice. Aksheta has been instrumental in promoting the message Suljhao Magar Pyar Se, encouraging peaceful and communicative dispute resolution across the country. Welcome, Aksheta. Thank you so much for joining us.
Thank you. Thank you so much.
Now, without further ado, we are going to divide, we've divided this panel discussion into a few sections. The first, we'll begin with a few questions with the panelists on different topics. Later, towards the end, we have about 20 minutes or so reserved purely for interaction with the audience. So if you have any questions, please feel free to drop them in the chat box, or you can also ask them directly to the panelists at the end of the session. Now, with that, the first topic that we want to talk about today is the use of ODR in SEBI, RBI, and banking and finance disputes. So, without further ado, Aksheta, uh, my first question is for you. Could you provide some examples of successful ODR implementation by SEBI and their impact on dispute resolution efficiency in SEBI?
Sure, definitely. So I think it was like such a collective win for all of us in the ODR space to see a regulator of such stature take such a bold move in saying that, hey, we want the entire securities market to now adopt ODR. And as ODR players, I think all of us, it was like honestly a breath of fresh air, lot of like grunt work and hard work. I think the rest would also be able to throw light on it. But for those in the room who don't know, so SEBI had put out a circular saying that the securities market of India are now going to adopt online dispute resolution as their main mode of dispute resolution for the investor market. And the portal that's being used is called Smart ODR. One of the cool things, if anyone's like really interested to look at it, is there is a public dashboard that is available to all of you to see. So all of us in the ODR space provide services on Smart ODR, and you can see the securities market stats completely on the dashboard. So I think it's really nice for us to be able to track, for all of us to be able to track what it looks like for such a regulatory body to get in, start ODR, and is ODR working? What's happening? What regions? There's a lot of accountability on all of us as ODR players as well, right? And I feel like in the last couple of years, everyone's been asking all of us, like, does ODR work? But why? Who's doing what? Everything is there. So my sincere request would be, please check out that public dashboard. Yeah, I think it's been great. It's not easy, I think, for everyone involved to get this done. It's always easier to maybe also switch to a let's try hybrid and then move online. But to take like this sort of leap and get all of our stakeholders in together, it's been excellent. So I think the biggest in the last 1 year would be that India has smart ODR, and the fact that all of us ODR players who've been doing this for so long actively, like we were all ready, ready to go. I remember in meetings, all of us ODR players were like, bring it in and we're here. Like we're here to provide these services. So I think that's been great.
Yeah, thanks for mentioning that, Aksheta. I've also shared a link to the Smart ODR dashboard in the chat box for anyone who wants to view. So, just pulling out a few stats from what I can see, on the SEBI, Smart ODR portal, a total of 3,000 disputes worth over 191 crores have already been successfully resolved, and the total claim value for the dispute submitted exceed over 350 crores. So much more, a lot of such more information is already available, publicly accessible, and that's what the SEBI ODR, smart ODR mechanism has done. So my next question is, a little bit along these lines for Vishwam. Could you please tell us how SEBI has incorporated these ODR mechanisms in resolving disputes related to securities and investments?
Sure. Thanks, Mohit. So almost about a year ago, so we actually recently just crossed like the first anniversary of ODR and securities market. But about a year ago, SEBI came out with a circular on the 31st of July for online dispute resolution, basically revamping the complete dispute resolution mechanism in the securities markets. And what we have is now a multi-stage process where the ODR process kicks in from the smart ODR portal that Akshita was mentioning. So the first step is generally conciliation, where all disputes which couldn't get resolved during the grievance redressal process as part of the SEBI scores. So SEBI scores is another platform for grievance redressal. They sort of flow into conciliation. There's another pre-conciliation stage as well, but the ODR sort of really kicks in from the conciliation stage, where we've got about 21 or 31 calendar days to try and settle the dispute, which is sort of pretty aggressive timelines. But so far, I think most of us have been sticking to them. So we've got about 21, 31 calendar days to sort of resolve it within conciliation. And the fees for the conciliation is generally borne by the market participant. So to give you an example, we've seen disputes between investors and listed companies, between investors and mutual funds, between investors and stockbrokers, which is probably the biggest in terms of volumes, between investors and depository participants, RTAs, and others. So the scope is actually pretty broad. The ambit is pretty wide, and SEBI's been increasingly, giving the signals that it wants to bring more and more disputes within the securities market into ODR. And that includes some of the slightly bigger ticket disputes as well, which would eventually flow into ODR across securities markets. So, and after conciliation, so if there's no settlement between the disputing parties, it basically moves into arbitration. Again, we've got sort of fairly strict timelines within arbitration as well. Uh, if the dispute exceeds 1 lakh, we've got 30 days plus another 30 days, which can be extended. So a maximum of 60 calendar days to sort of resolve disputes. And this includes disputes which sometimes run into crores, where then we've got a 3-member tribunal. But for most broadly, for most disputes, it's you mostly a sole arbitrator and sort of resolution within 30 or 60 calendar days. And the interesting part is that it's end to end within 60 calendar days, so that includes the issuance of award to the parties as well. So in a nutshell, you can pretty much have your dispute resolved within, if it's a conciliation within less than 31 calendar days, and if it's conciliation plus arbitration in pretty much about like less than or approximately 3 months, uh, which wasn't, of course, the case earlier and isn't really the case in other sectors as well. So it's a fairly sort of watershed development in India and globally as well. I think recently the American Bar Association has also sort of captured this development. So that's been sort of quite landmark in that regard.
Yeah, thank you. Thank you for explaining that. I think something that the highlight for me would be that, one, conciliation takes roughly 30 days to resolve, and within arbitration, about 30 plus additional 30 if it is over a lakh. So, maximum of 2 to 3 months, and for an end-to-end solution with the SEBI Smart ODR portal. Uh, that's amazing, and that's definitely good news for everyone who's who may have security or investment related disputes. Thanks, Vishwam, for explaining that. My next question in this segment is for Deepika. So, Deepika, my question is, can you explain, in your opinion, how effective has the ODR system been in reducing the backlog of banking related disputes in India?
Sure, Mohit. Thanks for that question. Um, So this is going to be slightly nuanced. Why I say this is we are not really looking at ODR's intervention at this stage in terms of whether it has actually reduced backlog in any institution or even in judicial system. This is particularly the case with banking sector disputes because what we are looking at addressing are those disputes which previously did not have formalized mode of dispute resolution. We, of course, have civil courts. We have debt recovery tribunals, as most of us are aware. But with each of these existing forum, there is a threshold. There is jurisdictional requirements. For instance, with DRT, there is a cap of 20 lakh and above for banking sector disputes to come in. So there were a large chunk of smaller value disputes that were left to sort of, explore other ways of resolution. And we all are aware of, what they can be from having agents call loan defaulters up to many other informal means. Or there were, sole arbitrators who were unilaterally appointed by the banking sector, by the banks themselves. Therefore, what we are looking at doing at this phase of ODR development in the country is to really provide a formalized mode of dispute resolution for these crores of disputes that otherwise did not have any avenue. And of course, you could go to civil court, but we all are aware of the cost and time implications that exist over there, which essentially meant that most of the banks used to write off. And of course, when you come to NBFCs, there are several criteria that need to be met for them to be serviced by DRT. Therefore, for a large number of NBFCs, they actually had to write off their loans.
with the ODR coming in, what we are essentially providing is a structured way of addressing these disputes through qualified, trained dispute resolution professionals. Therefore, I wouldn't look at from the prism of reducing backlog, but essentially creating an avenue for dispute resolution itself, which I think is a much bigger contribution with larger implication on financial market than anything else.
Well, yeah, that's definitely a fresher perspective, and I really appreciate how you look at it. And it's not about, currently at least reducing the backlog of cases that have gone to court or are, that are already following some pre-existing process. This is about giving access to those cases that earlier did not have a mode of dispute resolution which was either affordable or appropriate for those cases. And so now all of these cases which were under a lot of these different thresholds where it wasn't feasible for users to get their money back. Now, all those cases can come to ODR and be successfully resolved through ODR services. Uh, that's Thank you so much for that. Now, this brings us to the next segment that I want to talk about, which is the regulation of ODR. Currently, we know there is very little that anyone can definitively say that this is how ODR is regulated in the country. So maybe to try and shed a little bit more light on this topic, Aksheta, my first question is for you. Uh, can you explain what impact does the Mediation Act have on enforceability of ODR related settlements?
Sure, sure. So I think one of the great parts of the act is the fact that enforcement as a decree is now a thing, right? So the Mediation Act, it really has like a provision that now allows that once a settlement agreement is reached and recorded under this act, it can directly be enforceable in a court of law. Now, having something that clearly written down, I personally feel is extremely helpful because people have the same question around this poor concept of mediation, which is so good. So now that it's clearly written down there, I think that's a win in itself. I think also the fact that could be biased because we're in the space of ODR, but the fact that online mediation is also like categorically written down in the act now, huge win. Was it like needed? Would we have stopped working if it wasn't there? No, but it just makes life so much easier now that the word online mediation literally is written in the act. So I would say that these are the two things that really stand out more from my point of view.
Has there been, could you give any examples of any settlements that have been, successfully enforced either pre-mediation act or post-mediation act at Summer?
Yeah, so to be honest, right now, since getting it notified and all of that is still up in the air, we have personally seen that people are still sticking to conciliation, something that they're more comfortable with, have been using. But the shift will come in. From Sama's point of view, right now, for the disputes that we're handling, I wouldn't have any examples there. But yeah, I do feel once there's more clarity on the act, it wouldn't be difficult for people to sort of switch over there and then us seeing success in that space.
Sure. So
Yeah.
just to, if I hear you correctly, currently, people or ODR services or ODR settlement agreements or awards are still being enforced under the previous Arbitration and Conciliation Act. However, once the Mediation Act once it does become notified and enforceable, then there are, stronger provisions for direct enforcement, and also recognition of online mediation.
True, true. And this I'm speaking on behalf of Sama. If anyone else has any sort of examples, that would be great. But yeah, that's how it is working now. Everyone's very pro mediation. They are still doing mediation right now. But like you stated correctly, it is falling under it's a conciliation award at the end right now because they're more comfortable. But
Got it.
that switch will happen. Yeah.
Got it. Thank you. Thank you for that. My next question is for Vishwam. Vishwam, can you explain how the Information and Technology Act, the IT Act, how does that facilitate the legal recognition of electronic agreements or signatures in ODR processes?
Thank you, Mohit. So the IT Act, so I think as far as electronic signatures, there's probably more confusion because the law has been sort of fairly clear. that there shouldn't really be any distinction between an electronic signature versus any vetting signature, for instance. And if you look at the relevant provisions there in the Act itself, so if you look at Chapter 2, the Section 3 and 3A, and 3A sort of expressly recognizes electronic signatures. And if you read that with sort of Section 5 of the IT Act, which is really about recognition, it sort of makes it clear that, as long as a document is electronically signed or signed with wet ink, there shouldn't really be any problem as such. And from a legal standpoint of view, electronic signatures are as much admissible as wet ink signatures are for any record or for any document. Having said that, we've still come across issues, or we've still come across people who would rather prefer wet ink signatures than electronic signatures. I think it's probably just the mindset sort of shift or mindset, but I think we probably don't need any more clarity or any amendment as such in the law to really recognize electronic signatures because it's already covered into the IT Act.
So, just to confirm, your experience with enforcing electronic signatures has been mostly seamless. Like there haven't been any issues with the IT Act per se.
Yes, we at least we've not seen any challenge or any electronic signature not being accepted by a court or a tribunal.
That's great. That's great to hear and very promising for users so that there is usually a lot of hesitation of whether should we physically sign it or will this online signature work. So I think that definitely would restore a lot of confidence with the users that yes, electronic signatures have the same validity as physical ones. Now, Deepika, my last question in this segment for you is from a policy perspective or from a best practices perspective, what are some best practices for ensuring compliance with ODR regulations across different sectors?
Um, I think I will take off from what Akshata was saying. There is no one umbrella ODR regulation or legislation at the moment, right? It is mostly driven by individual sectors. And SEBI is one such example where an individual regulator has put together a set of requirements, a set of process, and a set of criteria to assess the performance of ODR institutions as well as various actors involved in dispute resolution, including the neutrals. Therefore, when it is a segment such as that, where there is clear-cut set of rules in terms of what needs to be done by the ODR platform, institution, as well as arbitrators, mediators, conciliators, whoever is onboarded, then it is about complying with them. Just to give you an example, for instance, SEBI itself today tracks around 150 odd data points, and Vishwam and Akshata can correct me on this, but roughly it is around 150 data points per case that are tracked on a regular basis. And this is as per the requirement laid down by SEBI itself. And this is meant to boost confidence in ODR ecosystem overall, which is why all the ODR players also are welcoming this level of accountability that is being expected. And as Akshata mentioned, there is also a dashboard where you can see some of these data indicators publicly, but a lot more is getting captured internally and shared with the regulator. And I think this sets a good model for other regulators to follow. I think currently with the legislations, Mediation Act recognizes online mediation, recognizes online dispute resolution, and then hopefully as and when Arbitration Council of India is established, there will be a separate set of protocols identified for online arbitration. But until we reach that stage, I think the existing model that SEBI has pioneered can be adopted by other regulators. And that is the best way to ensure that we are also, as ODR players, curating our own services and products to cater to specific categories of disputes. Because SEBI market itself is securities market, right? It requires certain level of understanding of the dispute category itself. So there is a lot of ecosystem building that is happening to cater to those disputes. If similar model is adopted across board, and that is initiated by creating certain protocols and regulations, it will also become easy for ODR service providers to adhere to those regulations. I see this heading in this direction rather than looking at any umbrella ODR regulation as such.
Yeah. Yeah, I think you're right. Absolutely that SEBI's current model, like you said, identifies over 150 data points for every case. And out of that, that's what the analytics and the dashboard presents to the user in a much more concise manner. Uh, and just on the point of protocols and best practices, it would be very essential to also mention the Justice Protocol, or I think it's known as Pulse now. Or there's also another one. It's called the Justice Protocol. It's for the regulation, or it's a set of rules for dispute resolution services on blockchain. So there are, these protocols that exist, and like the SEBI one, I think these models are great in terms of getting standardization and having accountability both for the users and from the platforms. So thank you so much for sharing some more light on this topic. We are moving, we've covered half of the questions. We are now, moving on from SEBI and to a little bit more on the appointment of neutral in ODR platforms. So, Aksheta, my first question is for you. Could you tell us what are some key criteria for appointing neutrals in ODR, and how do you ensure impartiality and expertise?
Sure, sure. So, as we all know, right, it's really crucial who's helping you solve your dispute. Sometimes we've also noticed that it's easy to assume that a low stake matter may not need a lot of effort. The facts of what's going on may be simple, but sometimes you just have a difficult person with simple facts. So I think that's where it gets really crucial who your mediator is or who your arbitrator is when it comes to dispute resolution. So in our space, what we do based on just ground realities of how people have been reacting, subject matter expertise is really important. Just the comfort of your dispute resolution professional knowing the terms and being able to understand the concepts of what's going on. So even if you have something as small as a credit card dispute or something as small as a personal loan dispute, right? You still need someone who has some sort of knowledge about the banking regulations and what's going on. Because people are going to ask you a ton of questions. People are going to want you to explain what CIBIL is and what it's not and why it's not happening a certain way. And then having a mediator who doesn't know what's going on, it just leaves a bad taste. It's not like it can't get resolved, but what can get resolved in 10 minutes is probably going to take you an hour. So subject matter expertise is a big one. At Sama, language is a huge one. In a lot of cases, when you're upset, and I keep saying this, when you're pissed off, you're thinking in your mother tongue. No one is trying to think in English and then, figure it out. And so be it, right? You should resolve your dispute in that language as well. There's no points for resolving your dispute in English. You just need to make sure it's resolved. So making sure language. So usually what we try and do is make sure that we get a pulse of what languages they're most comfortable with, and then ensure that the dispute resolution professional can also speak that language fluently. That is a big one. And of course, your general like non-disclosures, making sure there's no conflict of interest, making sure there's general hygiene in the ODR process, which for all of us now it's not a big deal. It's something we just do. We have to do. Those are things in place. But subject matter expertise and language, I would say, are the two big ones. And since it's not offline, the region really doesn't matter. So if you speak Hindi and you're sitting in Tamil Nadu, you can like deal with any case, anyone who's like able to speak Hindi, right? I think these are the two large ones. But in order to also the pool that you're choosing from, we're a little cautious about who that pool is as well. So in our space, what we do at Sama is you have an onboarding process, which is extremely crucial for us. So that is you do the Sama like ODR course, which is like your refresher. just so that you know the basics and you would know your platform decently. You have a coach that sort of helps you for your first 3 months, and there is a mandatory 1 hour session with a behavioral psychologist. Over there, that's where you sort of, we as admin are just given some sort of cues on someone slightly stronger when it comes to their EQ, someone is better at sort of bringing in like a level of strictness. So there are a bunch of parameters there. That also plays a role in sort of who gets appointed for these cases. We've also dabbled with an algorithm with the help of World Bank in just being able to see like automated appointments and how that works out. So as the sample size increases, we're constantly working on that as well, which again takes in these parameters as well. Your more nuanced ones, and then things as simple as your language, your subject matter expertise, how many years you've worked, a whole bunch of parameters that come in there. So yeah, it's exciting. And I feel as all of us keep exploring new disputes as well, the requirement for what is needed is also automatically going to change. So our lives are constantly going to be exciting when it comes to neutral appointments.
Yeah, I mean, thank you for sharing, Sama's personal experience in this case. I think it's absolutely essential to match, the service providers with the preferences of the users. Like you said, the two big ones are industry expertise or case-specific expertise, and second is language. And of course, then there are various parameters. I'm very excited to hear that there are already algorithms that are used to match disputes or service providers with cases. Now, my next question on this topic is for Deepika. And so, Deepika, my question to you is, in cases where there may be one bank or a large institution which is repeatedly getting the same kind of neutrals in a manner, or from a pool of, let's say, 100 200 neutrals, about 50 or 100 of them are managing disputes for one bank. Does these repeated appointments of neutrals, to a particular party with a large number of cases, can this create any perception of bias? And how do we deal with this challenge?
I think that's a very fair concern to have, Mohit, and it is quite widespread as well. It's a concern that has been voiced across different quarters because this directly affects the confidence that the parties have in the dispute resolution process that they are expected to participate in willingly and voluntarily. Perception is an important element, right? Justice is only as good as the way you feel about it. Therefore, it is our responsibility as ODR service providers to create processes and protocols which are transparent, which allow parties to understand how the neutrals are getting appointed. But before I get into what it is that we at CORD are doing, or also lay out the general, lay of the land, I do want to bring in a reality check, which is that there are millions of disputes and there are fewer neutrals than what is necessary to cater to the large-scale disputes that we are currently seeing coming ODR's way. Of course, there is responsibility on all of us to expand that pool of neutrals, be it arbitrators or mediators. And we are constantly working on it, right? Ensuring that training is given, there is quality control, we have streamlined onboarding processes. So that effort is something that is continuous. But and I don't think we will ever reach a stage where we can, promise to have a sizable ratio between the number of neutrals and the number of cases that each one will handle. And this is the case if you see even with the judiciary, right? There are thousands of cases that each judge handles. But however, there the respect and the integrity of the institution is not called into question because of some of the processes that the judiciary adopts, such as roster rotation. No single judge sits on one category of disputes for years on end. It keeps changing. unless, of course, as in there are a few exceptions, we don't have to go into that. But roster change is a huge way of boosting confidence in the manner in which cases get allocated to various judges. And of course, the state's sanction itself in terms of appointment of judges, that also boosts confidence. So drawing parallel from that system to what we ought to do within the ODR ecosystem as well, we need to have, as I said, transparent processes which allows parties to know exactly how and why a neutral is appointed. And internally, we need to have certain algorithms, certain rules to one, check the quality of neutrals. And I'm sure all ODR service providers have certain parameters which help us filter out the neutrals based on the manner in which they have dealt with parties to the quality of judgments. So that is again a continuous process. But in terms of whether we will be able to immediately address that perception, I think it is going to be a journey. We will have to build ourselves to continuously boost confidence, and that is a responsibility that we have willingly undertaken. Given that we have come this far where people are bringing their disputes to us, I think it is our responsibility to ensure that in this crucial role of appointment of neutrals, we are as transparent and accountable as possible. And here again, I will bring SEBI's model back in, because SEBI's processes and rules themselves identify certain parameters for neutral evaluation. I think that also plays a big role in overall boosting confidence of the ecosystem.
Hmm. Thank you so much, Deepika, for sharing that. I think this is definitely a long journey, but like you said, as ODR service providers, it is your responsibility and our responsibility to make sure that the process is as transparent and we can maintain that user and investor confidence within the ODR process. So that brings me to my last question in this segment, which is for Vishwam. On very similar lines, Vishwam, in your opinion, how can the appointment process for neutrals be improved to enhance transparency and trust in ODR systems?
Thanks, Mohit. I think Deepika and Akshita have already covered some of the points, but I think just to make it more transparent, I think having some sort of checks and balances is quite critical. So I think one of the points that Akshita mentioned is, of course, like subject matter expertise, language. I think you really need a clear and sort of standardized criteria for selection, for onboarding, and then for appointment of the neutrals, whether it's conciliators and arbitrators. And as long as that clear and standardized criteria is probably also conveyed to the parties and to the neutrals, that would, I think, increase trust between all stakeholders, the parties who are parties to the arbitration or mediation or conciliation, as well as the pool of neutrals as well. So I think that is actually quite critical as well. And then, of course, some of the processes that Deepika mentioned, how we can look at the judiciary, for instance. If there's SEBI, for instance, then its circular has some of the measures around how you would, who can be appointed as an arbitrator, what is the number of years of experience they need to have, and then how you evaluate them. I think evaluation is actually quite critical. Uh, because once you've appointed someone on a number of disputes, you would be able to tell how they're doing, and whether they're doing good in certain number of cases or certain type of cases but not so well in the other, for instance, or how their conduct has been, how prompt they have been, whether it's with the parties, or how much has there been a delay in drafting the award or assisting in settlement. So I think the checks and balances, especially when it comes to evaluation, is actually quite critical. And then sort of feeding that back into future appointments, or feeding that back into how you deal with arbitrators or mediators who are not doing well, I think that is also quite critical. And another thing, I think, which will become I don't know if it's much of a problem right now for a lot of us, but which would probably become very critical going forward, is just like a fact finding mission on complaints received against arbitrators or against mediators, whether it's from the parties or whether it's from other co-arbitrators in a panel. I think that will be quite critical, and there'll probably be a lot of eyes as well on that, in terms of how that's been dealt with uh, as part of that exercise, but also going forward as well. And if we can sort of do that in a fair and independent manner, I think that would then build a lot of trust within the system. That not everyone has been able to become an arbitrator, and if they've done something wrong, then they've not been repeat appointed, for instance, and there have been repercussions and consequences. So I think all of that is probably some of the key points for building trust and transparency.
Hmm. A feedback system, like Sangeeta ma'am also mentioned in the chat box, seems to be a very reliable method. But again, this feedback system, whether it's maintained by the ODR service providers, whether it is maintained at like some other third party, neutral like list of service providers, like we have Trustpilot for a lot of these online shops and things like that. Now, but this does highlight, this segment highlighted a few important things for me. One is that although we have a significant number of neutrals who are interested and available to resolve cases, in comparison to the potential inflow of disputes which is now flowing into ODR, there is still a challenge to ensure, variation, and to ensure that we can diversify the appointments. And that is a challenge that we have to try and fix immediately. But like Deepika, you shared that as service providers, we've been facing different challenges in the past. Right now, on the appointments and neutrals, appointments of neutrals challenge, we have to maintain the trust of the users, be transparent in our processes, and try to follow the best practices, some of which are also followed or seen in the judiciary. uh,
Just one quick intervention there.
Mhm.
One of the things that we have also brought in at CORD is provide an appellate mechanism. It is an internal appellate mechanism. So if there is any complaint, any grievance with respect to the quality of the service provided to you or the appointment issue itself, then you can elevate it within the platform. I think that is one other way of ensuring that the clients, the grievant, the parties who come to you have that confidence that they are not left in the dark if they are not satisfied with the process that they have gone through.
Would you be willing to share a little bit more about this appellate process?
The process essentially is two steps, where in the first level, you either through arbitration or mediation go through your dispute resolution process. And once you receive the award or during the process, if you want to escalate any issue, you have an avenue to go into appellate mechanism where a new neutral is appointed, or if it requires that a panel of neutrals be appointed, that is also something that the core rules provide for.
Thank you. Thank you for sharing that, Deepika. That's definitely very interesting. Uh, for me, this is the first time I'm hearing for an appellate mechanism in the ODR space in India. So thank you for sharing that. Now, since we are in the final quarter for our reserved time for Q&A, this brings us
Wait,
to the
may I,
last.
may I just add something on here, please? Which is very
So
important to the discussion that we are actually having.
yes,
If you
yes,
don't
Mr.
mind. If you don't
Yes,
mind.
Prithvish.
I'll just take 1 minute of your time. Deepika, Akshita, Vishwan, thank you so much. Mohit for enabling this. Now, my question is, we were all talking about the mechanisms to appeal something, right? Why are we not looking at the appointment itself? See, I think Deepika said that, a certain mediator, a third party will be appointed. See, appointed means enforcement, right? So can we take a little step back here and talk about how the two parties to the dispute are going to choose their mediator rather than somebody appoint them? That is the core concept of mediation, right? Win-win situation, you take your own choices. I think the concept is not far removed. I think it's there in the US also, where the jury is also chosen by the both parties in litigation. So I just say that and a quick uh, mention there. So I'm sorry I interrupted you guys, but I just want to bring this on the table. I think, Mohit, it's a very important issue. The appointment should be removed. The choice should be clarified. Sorry about that.
Thank you.
Sorry
Thank
about
you
that.
for sharing. No problem, Prithvishji. Thank you for sharing. maybe we can introduce this as a question for the panelists across the board. And since we are before moving on from this topic, what do you opened up where instead of appointing mediators or arbitrators, where parties are given the choice. Although, of course, the most common problem over there is that it is difficult for the parties or to get them to agree to one neutral. Beyond that, what are your thoughts on this process?
Shall I just I'll just take a crack at it. And then
Please.
yeah. So just correct me if I'm wrong. I also do feel the appellate tribunal usually, at least we've seen, is more online arbitration heavy. Your mediation cases, because of mutual consent and settlement coming through, I don't think we are seeing a lot of people have an issue in that sense, and there being like a sort of appellate tribunal that's needed internally. At least, like Deepika, just correct me if I'm wrong, but I think you were also talking more from the fact that all of us do online arbitrations and that sort of being a
Yes, because with mediation, as you rightly said, settlement is arrived at, and it is based on consent um, and collaborative participation. So less likelihood of there being a challenge.
Yeah. So I think all of us have that in the space. We all actively do online arbitrations as well, or we all have these tiered mechanisms. We're doing mediations, we're doing conciliations, and unfortunately, if we don't, I mean, the parties don't settle there, it then moves on to an arbitration. So I do. That was just one clarification that I just wanted to bring in terms of the question. And in terms of appointment of the mediator, I like absolutely agree. I think appointment of your mediator or arbitrator, there must always be the whole fundamental like reason of why we're doing this is your party autonomy and how you want to sort of have. Again, it depends on who your two parties are, right? If you're two individuals sort of coming to one of us as ODR providers, it's a lot easier for them to sort of just go through our panels, pick someone, or ask us to shoot out like 6 names, 300 names, 500 names, then you pick from that. That's an option. If you're looking at some of the work that all of us are doing, guys, I'm speaking on behalf of all of us. I'm saying something that's not right. You can just cut me off there. But from what I understand, if you have, let's say, enterprise on one side and then you have your customers on the other side, the concept of repeat player, stuff like that, which came up over there, again, having a set of rules of making sure who's able to sort of appoint that arbitrator or that mediator. What is our role as in like an independent institution coming in? What is the law saying right now? What are the courts saying right now? Your whole Perkins sort of comes in there as well. So yeah, I think, and all of these get hit at the enforcement stage. So as Sir rightly pointed out, the stronger we get at the appointment bit, the lesser I feel the challenges can come up towards the end. But I feel initially everyone, from at least what I've seen, especially when it comes to enterprises, were stuck with clauses that are unfortunately now outdated. Your sole arbitrator clause and stuff like that. So ODR players are almost providing a sort of mechanism to combat that. 10 years from now, we're going to have something clearer. We're going to have something new, possibly. So yeah, just to clarify that the appellate tribunal is more on the arbitration side for all of us. Mediation, I don't think we're facing any sort of issues as such. But collectively, I think appointment of neutrals, how they're being appointed, who's being appointed, major points that we all like keep in mind. And like, please feel free to add, Vishram and Deepika, if I've missed out anything, if you want to delve into how parties have access to appointments or anything. But yeah, just my 2 cents.
Thank you, Aksheta, for sharing. I think this does highlight, one or two important points. One, that the appointment process is streamlined in this manner for the benefit of the user. And secondly, for ensuring, consistency in enforcement so that later on there is not a question about appointment or any challenge to the appointment. So, is there anything else, Vishwam and Deepika, you would like to add on this topic?
I think I'm good, but I would just want to double click on the point that Mr. Prithvesh was making, which is that party choice should be given primacy. So there are essentially two ways, right? One party identifies a mediator or arbitrator of their choice, and that gets communicated to the other side. And if they agree, then all is well, right? You go ahead and appoint. But oftentimes, given where the parties are, that sort of consensus is difficult to arrive at, which is where we come in, and all the points that Akshata made, comes into picture. That is where we need to have streamlined processes, transparent processes, which makes the parties aware of why a certain neutral has been appointed. But oftentimes, when they come to us, they are looking towards us to make that appointment for them. And in that, we have to be as objective, and again, repeatedly using the word transparent as possible.
Thank you. Yes, Vishwa.
Nothing else to add. I think Deepika and Akshita have sort of covered all the points. I mean, I just like to, say that if the parties can agree on the mediator or the arbitrator, our jobs would be much easier. Like our lives would be much easier. But in practice, that's very difficult, and we've seen it very rarely happen.
Yeah, absolutely. I mean, I understand, having been at the grassroots level of bringing in cases for mediation and arbitration, I have personally seen and faced how difficult it is. I'm sure all of you have experienced this as practitioners in this industry as well. But thank you for, answering that bonus question, and thank you, Prithvish ji, for asking. I would request, any other questions, please keep after the session. We just have our last segment of the three scheduled questions, and then the floor will be open for Q&A for all the participants. The last topic that we are talking about today is, opportunities in ODR and how you see, the future of ODR. So the first question on this topic for Aksheta. Aksheta, what opportunities exist for expanding ODR in other or newer areas of dispute resolution, such as, for example, consumer or employment disputes, or so on?
Yeah. So, as in ODR it seriously can be used in so many more places, right? Like right now in India, I would say the spotlight is probably on the BFSI sector. It's been amazing, as we've been talking about, to see a regulator like SEBI sort of bring ODR in the space. But there is no restriction on the other spaces that you can use ODR as of today. Okay, of course, barring your major criminal. So just from our experience, we're seeing mediation itself being used in something as small as your tenant landlord issues. You have, and I'm not talking about the BFSI stuff that everyone's been working on, right? Landowners and builders. That's another big one, right? We're seeing that space coming in as well. Logistic companies are now also like stepping up and going, hey, I think our dispute category almost like fits into what everyone thinks ODR is today. So that's another space that's sort of coming in. I think what in Kerala, in Kollam, what they did recently, right? Releasing on-court, 24/7 on-court. Amazing, like awesome stuff. And that's what I think the pilot project right now is for check bounce cases. But just look at the sort of conceptualization, and I think with the help of Pukar and a whole bunch of really, really cool people coming together to try and push forth what is essentially online dispute resolution. I think I'm so excited to see how that plays out. We were really thrilled to see how that's coming in. And yeah, I think even abroad as well, consumer disputes, there are literally like your European Union has an ODR platform literally for your online consumer grievances. And it's nothing new. It's not new. It's just, I guess people are just going to catch on to it sooner. There are some people already doing it. Your e-commerce gang is already arrived using ODR. So yeah, I think from our vantage point, I feel land is another space where it can come up, your construction, your land disputes. And I know everyone keeps saying this, and I understand why the perception is that ODR is meant for small disputes and small value disputes. I just really want to reiterate, it is just the lowest hanging fruit for all of us to be able to prove that ODR is worth spending your time, money, and efforts in. It is just a low hanging fruit. So all of us, it is an open opportunity, an avenue for us as ODR players to be able to demonstrate that ODR works, but it does not mean it is exclusively something that can be used only for low value disputes. I say this everywhere I go because I feel really bad when people categorize ODR as something that can only be used for, small claim disputes. That's not true at all, from our experience. And we're really hoping all of us collectively in the ODR sector can soon start throwing out some solid examples and case studies just to be able to stop that from being, like this misconception on the work that we're all doing. So yeah, just a quick reminder. Of course, if there's something super complicated, you want to make that hybrid, totally possible, but this is not just for your small value disputes. I also think with the DPDP Act coming in, there's going to be a whole bunch of disputes in that space as well with regards to data and privacy. So yeah, I think it's just like all lights ahead for ODR in terms of dispute categories. And we'll keep, based on our low-hanging fruits, we'll keep demonstrating all the cool stuff that ODR can do. But it's just a matter of replication and then making slight tweaks to be able. No one would have thought the securities market can do ODR 2 years ago, 3 years ago. No one would have even brought it up in a conversation. Like, what about the securities? But like, literally check it out. India is slaying, like, when it comes to that. Like, an entire regulatory, like, insane, right? There are literally like advertisements being put out on ODR now. I never thought in my lifetime I will be able to send on my family WhatsApp group an ODR advertisement. So it's great. It's happening. It's going to happen. And dispute categories are also, I feel, huge. So yeah.
Thank you for sharing, Aksheta. I think I was also very impressed and very happy to see the SEBI ODR ads, on WhatsApp. I've also seen them now, but they've become very popular. But like you said, and I think this is very important to highlight, ODR does not have any industry specific, this thing. It is something which is highly flexible, highly adoptable across different sectors. And the most important thing to highlight is that ODR is not just reserved for low value cases. Even high value, complex commercial cases can be resolved successfully through ODR. And we will definitely do another success stories campaign to highlight this as well. Uh, Coming to my next question for Vishwam. So Vishwam, this is a little bit on the AI side. What are the potential benefits that you see of integrating artificial intelligence and machine learning into ODR platforms? How do you see that working and helping?
Thanks, Mohit. I think there are potentially, a lot of benefits, using AI, machine learning into ODR, and depends, of course, where what you're looking into ODR, and I'm probably going to bring in the courts element as well. I think one benefit that we've all seen is, of course, transcription. Supreme Court is transcribing constitutional judgments now, and we've seen increasing benefit of transcribing even arbitration proceedings as well, where you not only get a record, but that record can then be used for multiple purposes by the parties, either when it comes to submissions or for drafting judgments and awards. So I think that is one potential benefit in terms of just increasing trust, transparency, but also faster disposal as well. The other is, of course, I think around automated case management as well. You can use AI to sort of manage cases, manage documents, process documents faster, whether it's your OCR using AI, whether it's data entry being automated, etc. So there are a lot of benefits and opportunities there to sort of reduce your TAT for resolving the disputes, both arbitration, mediation, whether it's to case management, document management. Of course, that translates to cost reduction as well. Uh, and of course, the last one, which we've not really seen much in India, but that's around sort of predictive analytics, which is quite big in the US in terms of actually seeing how cases, how a dispute would be decided, or what is the prediction outcome based on how such disputes have been decided in the past across courts. So I think that the inflection point for that hasn't come in India yet. But as we have more and more data, and there's of course challenges with data as well, especially on the legal and judicial side. But I think that is probably a massive benefit as well going forward, which will indirectly help ADR a lot, because once you're able to see that this is my dispute, and that could probably be more for big ticket disputes. So this is how it's been decided in the past, and I only have a 30% chance of winning. They would prefer mediation or arbitration rather than actually going to court. So that's another then a big win for ODR. But I think that's probably more long term than less short term.
Hmm. Yeah, very, very interesting stuff for sure. I think For me, the highlight or the use of AI, I think, can be divided into two parts. One is as an assistant to the process neutrals or to the platform, whether it's in sorting case management, in sending communications, in transcribing templates, etc., etc. The second is, like Deepika mentioned earlier, where currently there might still be cases which are not coming to ODR for a number of reasons, or are not coming to arbitration or mediation because the parties feel like it is not worth the expense because it still is too much for them, right? If we could have AI enabled, arbitration or mediation at a highly reduced cost for the parties, I feel like there might definitely also be scope for, not shifting cases, but introducing a new category of cases into, ODR using AI-enabled processes. Just a thought, again, might be
Absolutely.
realistic, but I don't think it's impossible.
Absolutely agree.
So thank you for that, Vishwam. So my last question, which is scheduled for this call, for Deepika. Uh, Deepika, how can policymakers support the growth and adoption of ODR in India today?
Oh, there's plenty, uh, you know, policy makers. I would divide it into two categories, government and the judiciary in various ways. I think the most important thing is to walk the talk. Right, there has been so much that has been written about, discussed internally and publicly about why ODR is the need of the hour. India needs ODR, right? Indian legal health requires ODR to be a sustainable ecosystem. Um, and this is something that was thoroughly laid out in a policy document that Niti Aayog published a few years ago during COVID, when ODR was, brought to the forefront. It was a necessity and continues to be a necessity. In that process, and I had the opportunity of working with the expert committee, which was drafting ODR policy back then in my different avatar. Um, and back then, we engaged with multiple government departments. Um, and all of them were extremely positive and showed huge appetite to take on ODR for their internal grievances as well as grievances that their customers and consumers deal with. But so far, I haven't seen that translating into concrete policies. SEBI itself was a surprise factor, as Akshata also mentioned. We did not expect it, but the way it has taken off should serve as a lesson to other government departments, other regulators, that this is something that is here to stay and is beneficial for everyone involved. Say, for instance, MSME to consumer forums, they can readily onboard ODR in a much more credible, bigger way to ensure that it becomes a viable solution for people who are already approaching these departments. MSME has Samadhan portal, but it is about ensuring that it is broad-based and that it actually works for the benefit of people who are coming to these departments for resolution of disputes. So is the case with consumer forum. There are multiple consumer forum tiered consumer dispute resolution forums across the country, but we all know that they are also overburdened with cases. So ODR can be a ready way of reducing that burden on themselves while parallelly ensuring that consumers actually have a viable way of resolving their disputes. Similarly, every single government department in the country today is overburdened with litigation. This can be service matters to complaints and grievances filed against them by the public. ODR can be the first step, right, that they use to filter out at least some categories of disputes before it is taken to maybe public court system. Therefore, when I think of what it is that the government can do, there is plenty at that department level. It needn't all come from the central government PMO itself. There are several initiatives and policies that at the state level, at the local level, that can be taken to onboard ODR. And on the side of the judiciary, I think it's slightly trickier, but one case that comes to my mind is Vidya Drolia, where, with the stroke of a pen, they essentially said that cases that are to be referred to DRT, they will not have the option of ODR. ODR option is foreclosed for them. Judgments such as these need to be introspected, right? Either we take it back to the parliament to see if something can be done about it, or the judiciary itself is better equipped to understand where ODR is coming from and why it is necessary to provide that additional layer of filtering mechanism before things reach any legal fora, be it a tribunal or the civil court system. So I think overall there is plenty that can be done at policy and law level to further boost ODR in the country.
Yeah, thank you for explaining that so expansively. I definitely am in full agreement. One of my strongest opinions on this point, which people may disagree, is that I really feel with the Mediation Act as well, the government should have tried to take a little bit of a more proactive step and tried to make mediation mandatory. And if things didn't work out, we could have n number of ways to have the opt-out model, or maybe denotify the mandatory section a year or two later. But that was a missed opportunity. But there is still, a lot of scope for improvement in ODR policy to enable it, to make sure it's accessible, to make sure it's the first mode of dispute resolution before escalating, within the legal system. Uh, but thank you so much for sharing that, Deepika. Now, we have a little bit of time left for some Q&A. The floor is open for all the attendees. If there are any questions that you'd like to ask, please do so. We do already have a list of questions that we have received, but I think we have one. How can businesses leverage ODR to enhance their dispute resolution processes and customer satisfaction? Would any of the speakers like to take this one?
Yeah. So even before I feel like I say anything, I just want to let you know that there is an excellent resource specifically for this, which I think in the year 2022, there was an ODR handbook that was released on how businesses across sectors can actually just adopt ODR. What's the sort of homework you have to do internally? What are the goals you need to set? How you can do it? And then, of course, the fact that there are ODR providers like us that can sort of help in the dispute resolution space. So I'm just going to try and find a link and share it on chat. Maybe that will be helpful because it's a really comprehensive resource. Yeah, perfect. If anyone wants to add anything more, please go ahead.
Okay, any other questions, or if any of the speakers want to add to that?
For some reason, I don't know whether I'm not able to posting messages, but in support of what she said, ONGC is a government organization, and they've settled issues worth 11,500 crores through mediation. Okay, 43% through ODR.
I'm sorry, who's speaking? I can't
ONGC,
really tell.
oil and gas, ONGC. They're the biggest government company who's doing it through mediation. Okay, 11,500 crores is that 2023 to 2024 is what they've settled in mediation. 43% of it is through ODR. And if anything, my dear friends, COVID taught us we don't have to go out of our home for settlement. COVID taught us a lot, right? Let's focus on what COVID taught us rather than what COVID took away from us. Everything with regards to we are sitting at home and doing these things, COVID. So my point is very simple. how can we make the process simpler and more direct? Arbitration Council, ANC Act 1996. Why is there no appeal against it? Because it's very restricted, right? Very restricted to the extent that it says that unless and until certain clauses are not met, you can't challenge it. When we were all part and parcel, Mohit being a part of it, he's part of my of our entire WhatsApp group, which is like all over India. There was this concept that we are going to make mediation mandatory. Nobody agreed to it. The government. Okay. Second aspect, nobody agreed from the government to make themselves available for mediation. They said, "नहीं, हम तो नहीं आएंगे भैया. अब जो करना
So,
कर."
Prithvishji, if I may, just try to get a question here, I think it is how can we make the ODR process more direct and more simpler? If
Not
I heard
direct.
you
It's
correctly.
already direct. It's simpler. I can show you, Mohit, I will send you some stuff which I have received, WhatsApp messages, threats I've received, things like that. Send it to you. You just have a look at it. See, people are not open to it as of now. And the Mediation Act itself has not really made things better. They have not understood the concept of mediation because ये तो मतलब इतने सालों से pending है यार. You're
I
talking
think
about we
I
need to
think
kind of
I would
figure out
love
how
to
we
hear
get
the
through to them.
panelists' thought on this, on whether how can we make the process simpler?
Exactly.
And of course,
And,
there
and
are
I
there
think I'm
are a
not
lot.
sure Rakshita or Deepika actually once said there's also something called a psychological, I think Akshita it was because she's nodding ahead. Yeah. Hugely needed. Very time. And it's needed so much that anything we decide here in the absence of the people who are actually involved in it is not something that's really going to work in the long run. I'm sorry, that's my point of view.
Uh, yeah, I think if there's not a question there, I think well,
Question is,
thank
how
you
do
for
we make
sharing.
it simpler?
Okay, how can we make it simpler? Any
To
thoughts?
the extent that there is no appeal, as
Hmm.
the ANC Act, or limited in its appeal.
If I understand correctly, I think mediation settlement agreements anyway see a very, very like fractional appeal, and even those that are appealed are rarely successfully appealed. Uh, right? And I think for
Same with ANC,
arbitration,
same with ANC, Mohit. My question is this: when the question is asked with regards to the mediator, then
okay.
it becomes a question. Same as an ANC. Question the arbitrator. So my simple respectfully submit here is that please get the act to ensure that parties agree to them. Mediator is agreed upon, right? So let's get them to agree upon the mediator as well. Then nobody can go back on it. Right now, we are open to any kind of challenge. ये इसका भाई था, उसका भाई था, whatever keeps going on.
If I understand correctly, I mean, even when anyone is making appointments, I think the
Sure.
general best practice is that there has to be a conflict of interest check, where we ensure that the mediator doesn't have any personal or professional relationship with either of the
Absolutely.
parties or their counsels. And so, regardless of whether the parties have agreed to the mediator like out of their own volition they've chosen, or whether the mediator or arbitrator has been appointed. When this conflict of interest check is done, parties, if I understand correctly, essentially waive their right of challenging this appointment in the future, unless they come across some new information that they did not have earlier, or unless there is, allegations of serious corruption or fraud. Is that correct, Vishwam, Deepika? Anything you'd like to add on those lines?
Thanks, Mohit. So generally, yeah, so we would sort of, do a conflicts of interest check as well as take their declarations on being independent, impartial, and sort of neutrals. So I think that is, of course, done at each ODR service provider level, and then of course there's a record of that declaration as well in case that has to be produced in court later. But of course, this problem is not limited to ODR. Of course, arbitration, mediation, conciliation have been around for like hundreds of years, and sometimes there are allegations of fraud or the arbitrator not being independent or impartial, even though they said that they were, for instance. So I think this is a problem which I don't think is specific or limited to ODR. I think it's a general ADR problem that we need to look for a solution for.
Yeah.
How do you solve this? That's my question.
I think the
We,
checks
Government
can be.
refused to make it mandatory.
I mean, I think this is a question that I feel like the entire industry has been questioning, or like the
Exactly,
dealing
Mohit.
with for the
That's my
last couple
problem.
of years.
Yeah, that's my
Uh,
problem.
of course, if we have more thoughts on this, we can, share, but I'm
We should have
positive that
probably
we
another
might not
session
reach
on
a
this,
solution today.
but I don't want to intrude more on this session right now. You guys
Yeah.
carry on. But this is a session which I would like to raise this question. Let's make it more
Yeah.
involved than it is the way it is.
I appreciate the sentiment, Prithvishji, and thank you so much for sharing. Okay, so we have another question. What challenges do financial institutions face in implementing ODR? In your experience, what are some challenges that they've faced, and how have you addressed those? Again, it's open to any one of the panelists.
I think there are plenty, so I'll just pick one off the top of my head. Our pitch has been that ODR is extremely convenient, accessible, affordable. You can resolve your disputes from the comforts of your home, so on and so forth, right? However, when it comes to on-ground realities, especially say from a bank's perspective, which disperses loans across various geographies, across various categories of clients, in terms of, say, the education background to economic background to where they are currently stationed across the country, it becomes tricky to ensure that your pitch remains equally applicable to all of them. The pitch that it is accessible, the pitch that it is convenient and cost effective, right? All these three may not be equally applicable across all categories of disputing parties. And that is one key gap that we are constantly striving to bridge. A loan may be granted to a company, to an individual in some remote part of the country. Now, ensuring as a neutral institution that you get both the parties to appear before the arbitrator or the mediator, whatever the process may be, is a huge challenge. Right? It requires certain skill sets, it requires capacity, additional training, because as we've been talking, there are regional variations, there are language variations, all of which we need to equip ourselves with. Right. So it is as much of a challenge as for the ODR institution as it is for the financial institutions as well, in choosing a category of dispute which will give them quick results, or at least better results than what they have been experiencing so far. Having said that, I think it is a journey that all of us are collaboratively undertaking, because we need to build this capacity to be in a position to actually help the clients who are coming to us, be it individuals or the banking system or any other categories of clients, right? It requires that constant investment across various categories of skills, and that is what we are all striving to do. So it is not without its challenges, but that is the journey that we are on. And it is actually linked to, I think, one of the other questions that I happened to see in the chat box, which is related to technological developments. I think the beauty of ODR ecosystem is that it is going to speed up innovations at a great pace, as in at least at a pace that we haven't seen in India before, right? The advantage is that we are working in a space where we can quickly test, we can see what works, we can see what doesn't work, and accordingly build solutions for different different kinds within the population and scale it up. Something like this is unthinkable within, say, the government or even within the judiciary. With the recent strides that we are talking about, say with Kerala or with the Supreme Court transcription services, most of them are solutions which were tested outside and now they are being brought into the public court system. So therefore, what we are going to be seeing with ODR is not just being able to service a lot of people who were otherwise left out, but even in terms of contributing to the upgradation of existing systems, I think that is going to be at a much quicker pace than what we have seen so far.
Yeah, I think that you're absolutely right. I agree with this sentiment. I feel like ODR is developing and progressing so drastically in India that it could not anywhere else because of certain factors that make technology and development and adoption easier over here, and the kind of innovative tools that we can build, that we can test out. So yeah, I think this is India's definitely one of the pioneers in ODR, and I think with that, we have maybe a few minutes left, but I would prefer to not rush in the end, and would like to conclude. Thank you so much, Deepika, Aksheta, Vishwam, for coming here. You are all pioneers in the ODR space, and I'm very grateful that I've been able to have you here today. I'd like to extend my deepest thanks to everyone who's made this event possible. Thank you for all the participants for your active participation and engagement. And your interest in this discussion is crucial for driving the future of ODR in the country. Uh, on the note of tools that we are talking about, there is a small announcement. I have been working on something that I'm very happy to share with everyone. There is an AI-enabled mediator bot that I've been working on called Ask MM, which is accessible on our website mohitmokal.com. Or mohitmokalmediation.com. AskMM is a unique AI tool that can help with a broad range of issues, including especially for students practicing negotiation or mediation for any simulated problems or real life cases. It can help prepare strategy and negotiation plans. It can help run simulate negotiations as one party with the user as another party. It can also mediate a dispute as a mediator with two users negotiating against each other. It can also give the users feedback on how to improve their negotiation or mediation skills. So please feel free to test it out. It's currently live on our website. And let's continue the momentum from today's discussion as we work towards a more accessible and efficient dispute resolution system in India. Thank you again, everyone, for joining, and have a good evening.
Thank you, Mohit. Thank you, everybody.
Thank you. Thanks, Mohit. Thanks, everyone.
If we could have a quick picture with all the participants who are here, anyone who would like to be in the picture, just turn on your camera. We'll take a quick one and we'll be done for the day. Okay. Okay, I'm counting 1, 2, and 3. Thank you. Asta, you can take a few more. Yeah. Thank you, everyone. Thank you so much for your participation. Thanks for
Mohit, let's
joining.
talk.
Yeah, we'll converse. Thank you so much, Prithveshri. Thank you, everyone. Bye.
Thanks.
Bye, bye,
Good
Mohit.
evening. Bye, everyone.